Thanks so much for joining us. We'll get started in about 5 minutes. Thanks for joining us. Just wanted to let you know you're in the right spot, and we will get started with the webinar in just a few minutes. Hello, everyone. Thanks so much for joining us tonight. My name is Shelby Hayes, and I'm the marketing director at Evans and Davis. And I'm just here to kind of get us kicked off and get this webinar rolling. We are going to be talking about special needs planning for your child and really just looking at ways to protect your kiddos when they're turning certain ages and then also even after you're gone. Our plan for this evening is I will be introducing our attorneys, and then John Weaver and Taylor Kincannon will be taking over. And they're going to first start out by talking about estate planning, because that's really going to be the foundation for your special needs planning. Then they'll jump into the special needs planning. And then from there, they'll also talk about some of the public benefits and different ways you can qualify for those. Of course, we will be taking your questions. I think the easiest way to get those answered this evening is going to be by sending those in via email. So we will get those email addresses pulled up for you here in just a minute so that you can send those in to John and Taylor throughout the evening. John Weaver is one of our attorneys and partners at Evans and Davis. He got his JD and MBA from OU, and he's licensed to practice law in about 7 states across the US. He's been doing this for nearly 20 years. So a lot of experience. He works with a lot of families who do have special needs and really just has a lot of experience on this topic. Taylor Kincannon is another one of our attorneys who has really done a lot of the work and a lot of the legwork when it comes to our special needs planning. He went to the University of Tulsa College of Law, and he also serves on the board of directors of Victims Impact Panel of Oklahoma. You're going to be hearing from both of these guys this evening, and here are their email addresses. Like I mentioned, we do want to answer your questions, but I think sending an email is going to be the best way, so that you don't end up with just that attorney answer of "it depends," because in truth, a lot of times it does. And a lot of the questions, especially related to this topic, the answer to that is going to be "it depends." So if you're sending those in via email, we can dig in a little deeper and better answer those questions for you and for your situation. So thank you so much for joining us tonight. I will go ahead and hand this over to John and to Taylor to get right on into our topic.
Thank you, Shelby. I really appreciate the introduction. We're really excited to be talking about this topic. I think it's something that is near and dear to our hearts in the firm. And also it's an area that I think there's a lot of misinformation about that. I hear it time and time again, folks coming in with ideas about things that just aren't correct. And so hopefully we can provide some valuable information to you and your family. And also maybe have a little fun while we're doing it. Since I can't hear you in the background, I'm just going to assume you're laughing at any dad jokes I tell. So with that, kind of want to get going and tell you a little bit about our firm. We have 18 attorneys, over 40 when you include staff and all the people that help make this work. We are licensed to practice in 18 states, and we help folks in 18 states, and that's something we're really proud of and growing. Grown since that picture. Our firm is really a little different than traditional law firms. We're really just a proactive firm that's going to help you with your planning, and that's why it's a really great area of law to practice. We're not fighting every day. We're not going into litigation. We're really here to help you and your family be proactive and care for the people that you love. And that's what we're here to do. And that's really what our focus as a firm is. What our focus is tonight on special needs planning is super important. But as Shelby said, you have to have the foundation of how that plays into your estate plan, because you can't really have one without the other. Having a special needs trust without having your plan in place isn't going to work. And so we're going to show you how those work together, with the start with Taylor kind of walking you through exactly what is estate planning and what we mean by that.
Sure. Thanks again, everyone, for joining us. Whether you are a parent of somebody with a special need or disability, or an advisor who works with families in that scenario, we're happy that you're here, and hopefully we can shed a little bit of light on some of the important topics that we're going to cover tonight. So what is an estate plan? Like John said, we're starting here kind of with the foundation of planning in general, and then we're going to walk through special needs planning, including special needs trusts and the various types of those soon, but just kind of want to get a good baseline of what an estate plan is. So an estate plan is a vehicle that you put into place that moves your assets from you to the next generation. It's a comprehensive plan that governs your personal and financial affairs. So this is everything from a revocable trust or a will, sometimes both, to powers of attorney, HIPAA authorizations. All of those documents work together to create your global estate plan. So what are your estate planning options? Generally, in pretty much every state that we practice in, you have three options. The first is to have no plan at all. So no will, no trust, nothing in place. And at that point, when you pass or when you're incapacitated, state statute's going to dictate what happens to your assets. You know, who's going to inherit those assets, who's going to be in charge of stepping into your shoes and moving those assets from you to the next generation, or to whoever your beneficiaries are. There's a drawback here in that in order to move those assets to your beneficiaries, your heirs, you have to go through a process called the probate process, and we'll touch on that here shortly. Probate generally entails hiring an attorney. It requires hearings. Everything is public information, and generally it's pretty costly as opposed to doing your planning up front. And the biggest drawback is 9 times out of 10, state statute isn't going to follow what your wishes are for your assets, particularly when you have beneficiaries who may need to qualify for public benefits when you're gone, may need additional support, may need some special needs planning or disability planning. And we'll touch on that briefly. The second option is just to have a basic will. This is probably the most commonly thought of option. This would be, you've written down what your wishes are, who should step into your shoes, where your assets should go. But again, another major drawback is now we've just added a step to that probate process of the will has to be approved by the probate court to proceed, and for your wishes that you've documented in that last will and testament to be followed. And the third type of estate plan, and probably the most common that our firm deals with, just because of the ease of use and other benefits, is a revocable trust. We'll touch on all of these trigger words shortly, but generally a trust is an estate plan that while you're living, you put into place, you move all of your assets into that trust, into the name of the trust. Generally, a revocable trust isn't going to change how you use those assets day to day, but at your passing, that trust dictates who's getting what, when, where, and how, which is another important distinction. Is in the trust, you can dictate some protections for beneficiaries, things like that. And so that's, kind of the estate planning options, or an overview of what your options are.
Yeah, and I want to hit on a little bit the reasons why you want to do planning, and why the folks that come to us are coming to us in the first place. I want to focus tonight mostly on that very last one on that slide, the controlled distribution of assets. You're going to see rather quickly why that's critical when it comes to providing for your beneficiaries who may be receiving assistance. And we'll go into what that looks like. That's going to be the topic of tonight's discussion. But please know all of those others are critical for a lot of other families as well. As Taylor discussed, and the avoidance of probate and the fees that are involved in that, the time that's involved, making sure that, your wishes are followed and that we're avoiding conflict where it's, well, mom always wanted me to have this, dad always wanted me to have that. That's a big part of what we're doing, is making your wishes known in a private manner, and that doesn't go through the court process. And so for often when we're meeting with the families, many of these reasons are coming to the forefront. Tonight, we're really just going to focus a lot of it on how those assets that are distributed to your loved ones aren't disqualifying them for that. But I do want to give, I feel it'd be a disservice if we didn't go a little bit further into the probate process to know exactly what you're avoiding by doing this type of planning. And Taylor's going to walk through that rather quickly.
Sure. So generally, as we said, probate is the process of moving your assets out of your personal name, out of your estate, once you've passed, to the next generation or whoever's inheriting that. You know, the probate process, you can see we've got kind of charted some the process here in our bubbles, all the way from filing the will, or if you don't have a will, filing your petition, going all the way through letting your creditors know that you've passed, and inventory telling those creditors and the beneficiaries and whoever else is interested what's in the estate, and all the way till it ends where everybody wants to get, which is distributing those assets. Through that probate process, there are a lot of variables here. Maybe in your will, you've said that you've set up a testamentary trust, which is just a trust that grows out of a will to protect your beneficiaries. That's great. Still requires the probate process. In your will, maybe you haven't been able to add some of those specific protections for your beneficiaries, or the privacy that you would like, that you would gain through a revocable trust, and a special needs trust or a supplemental needs trust. And so it's just kind of, probates take a long time, they're costly, and attorneys involved the whole way. And generally, we want to avoid probate as we move forward and discuss all of the trust-based planning options. Some triggering events for why you would need an estate plan, and we'll touch on a lot of these, and John has as well touched on a few already, but retirement, needing to qualify for public benefits, either for you personally, if something happens down the road, or helping your loved ones or a child qualify for public benefits. And then just, any major life changes, you either probably want to come in and discuss with us or with your estate planning attorney what your options are for estate planning when one of these major life events has happened, or need to update your estate plan based on whatever life event has happened. So sometimes a common question that we get is, do we need to come in every year and talk about this? Well, if something important has happened, or just for your peace of mind, let's review that, make sure everything's working the way that you were told it would when you put that plan into place.
So I want to describe what a trust is. I think there's a lot of misnomers like we talked about earlier. And I think in about 5 minutes, you'll understand what a trust is better than a lot of first-year law students, and maybe even some third-year law students. And understanding just the basics of what a trust is going to help you understand that specific type of special needs trust that we're going to create as well. When we say a trust, really all we're doing is creating a bucket. It's a bucket for your assets. Inside that bucket is going to have the rules. It's going to say who gets what. And for today's discussion, it's really how they get it, and when they get it is going to be key for this special needs type of trust. But this bucket is something that doesn't change the way that you all will live your life moving forward. You're going to carry this bucket around. You're going to have assets come into the bucket, go out of the bucket, but it's something that you carry, and it's something that you get to decide the rules that go into it. A trust that we create as a foundation for your plan is typically going to be revocable. And again, attorneys are notorious for calling the same thing 10 different names. Revocable simply means it's something that you can change. You can amend it. You can undo it anytime you want to. You want that to be the foundation of your planning for your loved ones, because life happens. You're going to want to change those things. You're going to want to change the people that play key roles over time when life happens. A trust will go from being revocable, where you can change it, to irrevocable whenever you can't make decisions anymore because of an incapacity or because of a death. I liken that to putting the lid on the bucket. No one gets to decide different rules. No one gets to take assets in or out. The assets and the things that are going on in your bucket are final. And that's really important, and especially when we're talking about special needs planning, because we have to be very detailed and we have to be very specific as to how the assets come out of the bucket. But one thing I think our firm is really good at, and I think that's going to be so important for folks, is what we call funding the trust. And that's the putting the stuff in the bucket. If you create the bucket, but you don't actually put the stuff in there, your estate still has to go through probate. So I want to make sure that that's clear. If the music stops and you still have something that you own in your name, your loved ones, even though you've done all the work of creating this trust, still have to go through the process of probate to get the assets in the bucket. And so that's why we're going to be diligent to make sure that we are moving properties, moving bank accounts, all of the life insurance proceeds that you have to protect for your loved ones, they flow into that bucket. They're not giving to anyone directly. A lot of what we're going to be talking about today is providing it in a specific manner for special needs trusts, but also we'll talk about when that's not the case a little bit and how we're protecting people as well. I want Taylor to talk a little bit about how the stuff comes out of the bucket. He's going to talk about, whenever we're sprinkling those assets out of the bucket and what that looks like.
Sure. So when you've passed, as John said, when the music has stopped, you've named somebody as the successor trustee who steps into your shoes, can't change the bucket. They follow the rules in the bucket for who's getting what, when, where, and how. More specifically, in your trust, you can specify, depending on who your beneficiaries are, whether that is your children, family members, other loved ones, nonprofits, churches, whoever is listed as a beneficiary in your trust, who's getting a piece of whatever's in that bucket. How are they getting this, and what rules can you add to your trust to protect the beneficiaries for what you've worked hard for and what you've grown during your lifetime, and to protect them, in this scenario, most importantly, how can I protect my loved one who has a disability or a special need from one, disqualifying them from any public benefits that they're receiving, or from, even just taking some assets that could sustain them and support them for a long time, and maybe spending them all within the year. That's true for an 18-year-old. My brothers are 24 and 25, and I don't trust them to receive half of my estate right now. So I can put stipulations into my trust for supporting them, but not just writing them a blank check, and that's going to protect them. I can also put more stipulations in there on depending on what the assets in that bucket are. Maybe I own a portion of a business, or I own some real estate, and then I've got cash and I've got life insurance here. Well, if I'm funding a supplemental needs trust, maybe I want some more liquid assets to go there, so that in that special needs trust, there are assets that are there to supplement those public benefits that my special needs trust beneficiary is receiving, while a business interest in some real estate can go to one of my other beneficiaries, and maybe they are previously involved in the business, or can own that business without being disqualified from any public benefit. So there are ways to, one, protect your beneficiaries from themselves, from creditors, from divorcing spouses, all of these things, and to kind of stipulate what assets you'd like each beneficiary to receive if there are special considerations here that one asset might benefit somebody more than the other.
Yeah, Taylor mentioned when those assets are coming out of the trust to your loved ones, doing it in a manner that is reasonable, making sure that it's protected, making sure that it's not going to people that you don't want it to, and specifically creditors. When we put the lid on the trust and it becomes irrevocable, that has a lot of credit protection. It has a lot of divorcing spouse protection because it's not been given to your beneficiaries. And that's really the key as to how do we protect this money, let it grow over time, but also provide benefit to people. That's where the trust really shines, because we're saying, hey, you get this money at certain ages or on certain milestones or when the water is calm, but we're not handing money over to an 18-year-old and saying good luck. We're going to say you're getting money for the things that are necessary to provide support for you and your health needs and your schooling, but we're not just dumping money in your pocket and letting you make bad decisions. And so When that money hasn't been given, and let's say there's a pending bankruptcy or there's a judgment against you because of poor decisions, that money hasn't been given out to that beneficiary, it's protected. And that's a huge thing in the asset protection of the assets that you've worked really hard for. I ask clients all the time, hey, you love your kids? Sure. You love their spouse? Sure. You want that spouse to get half of everything that you've worked for because this money's not protected? No, no one wants that. And so we want to make sure that there's provisions in a trust, just on the chance that a divorce happens, which we all know the percentages on that. So that's really what we're looking at in general when folks are coming to work with us in regards to providing for children. I want to take the next step and talk about kind of what we're here for today. The other methods of providing for folks who may be receiving government assistance, or some sort of need-based or special needs trust. What we're talking about here really is not disqualifying someone, making sure that we're giving the money to someone in a way that doesn't disqualify them for benefits. As I talked about earlier, attorneys call things 10 different names. And so I want Taylor to spend a little bit of time talking about, the terminology and talking about the names of what you're going to hear, and making sure we're all clear and on the same page as to, what exactly a special needs trust is and what a special needs trust does.
Sure. Like John said, we, as attorneys, we're infamous for using as many synonyms as we can. So a special needs trust, and we've referred to these trusts several different ways already. Much like Clark Kent and Superman, special needs trusts are referred to by different names. A supplemental needs trust, a special needs trust, a disability trust, a qualifying trust. Even sometimes they're called, dependent on what type of supplemental needs or special needs trust it is, a Medicaid payback trust. So there are just a lot of different terms that can all be referring to one thing. So while it might seem a little bit convoluted, just know that generally there are so many different terms for what a special needs trust is, but they all essentially accomplish the same goal. And so that leads into, what does a special needs trust do? It does a few things, most importantly, protecting eligibility for public benefits or government assistance, things like that, that your special needs or loved one with a disability might rely on day to day to take care of themselves, to live the lifestyle that they're accustomed to while you're alive, and especially after you're gone. $20,000 from your estate might seem like a lot in that instance, and it might seem like it could support them for a long time, but let's weigh that with the public benefits that they're already receiving and see how we can kind of tailor your estate plan to help that $20,000 supplement those benefits and not knock them off of that for a prolonged period of time. Special needs trust can provide a higher quality of life, so it can supplement what they're already receiving and ensure that they live the best life possible. It can provide a framework for the care and management of your assets. So it might say, that somebody is entitled to distributions to supplement what they're already receiving, and specify how your assets should be taken care of so that they can last for the lifetime of those beneficiaries and beyond. It allows you to protect your assets, like John has said, from creditors and from predators, because keep in mind, generally the special needs trust we're talking about right now, that is coming out of your estate plan, out of your trust, this has happened because you're no longer there to help take care of your loved one. And so we want to protect them from predators, creditors, anybody who would try to abuse those assets that have been entrusted for their care. And it extends the life of those assets, like we've said. It helps dictate who uses what, when, and for, or how for their protection.
I think, one of the big takeaways that I want everyone to leave with, and we're still got a lot of great information, but I think the big thing to take away is that you have to have a plan. And the folks that are, that have special needs children or providing for someone that has some needs-based assistance, you have to have a plan, because the reality is if you don't, you could be disqualifying your loved ones for benefits that they're receiving or will receive in the future. So, for example, let's say you've got a life insurance policy that pays direct. That money will get spent down and used until that child can qualify again. So, for many of the states we work in, they have a threshold of as little as $2,000. So, let's say that you've got assets out there and with life insurance, and let's say, for example, it's $500,000. That money gets used first before they qualify again. And that's a huge disservice to all of the hard work that you've done, all the planning and all the insurance that you have in place before those loved ones are going to benefit again. So that's really, at the end of the day, what we're trying to avoid is disqualifying them for those benefits that they so desperately need. You know, when we're talking about the special needs trust benefits of the planning, a lot of what we're going to focus on tonight is the financial security, just making sure that there's assets there and it's doing it in a efficient and proper way to not disqualify. But a lot of our conversation also is about your loved one's care, you know, making sure that you have a plan in place outside of just the finances that says, you know, this is how I want my loved one cared for. This is how I want them raised. This is the things that are important to me in my life, and how I feel my child or my loved one should be taken care of. And so it's really kind of a comprehensive plan. The finances and the assets are going to be a big part of what we're helping with, but we also want to be there as a sounding board for making sure that you've got a comprehensive plan. You know, if that bus hits you tomorrow, what does this look like, and how do we best navigate those rough waters when it comes to that? I want to spend a little more time talking about that means test. There's, you know, the acronym jungle that a lot of people have to go through when we're talking about qualifying. One of those things, you know, we're talking about basically 5 different federal means tested public benefits. There's temporary assistance for needy families. Obviously, we know about Medicaid. There's children's health insurance programs. There's the SNAP programs, the Supplemental Nutrition Assistance Program. And then a lot of folks are familiar with SSI, or Supplemental Security Income. Those are really the big 5 that we're talking about through the federal government. And most of those are means tested. And like we talked about on the previous slide, if you're over that threshold, you no longer qualify. And so we have to be careful of how your loved ones receive assets in life or in death. We can't just give assets often, because there's going to be problems with them having to report those assets and what that means for the things that they're benefiting from the government. And so, you know, that is a, you know, something that you have to navigate. A lot of folks have already navigated, but it's something you want your successor trustees that, you know, Taylor mentioned earlier, to be aware of, that their decisions on what they're spending money on can gravely affect what type of assistance they're receiving. And so that's that hurdle and that challenge can often lead to folks making mistakes when it comes to planning without the use of professionals. I often see folks come in and they say, well, I've left nothing to my child that has greater needs and has a disability, because I feel like their siblings will take care of them, or I've left it all to this other relative on the hopes that they're going to take care of the child that has greater needs. That results often in disastrous results. Money doesn't get to the people we care about. You know, marriages happen, divorces happen, money gets spent on things that aren't your intent. It just, there's a multitude of different things that can happen whenever we're not planning and we're not doing it with professionals that know what we're doing. The other side of that coin, instead of leaving nothing to the child that may have special needs, is leaving a greater percentage and saying, we're going to leave a whole lot more to this child who has greater needs, but not doing the further step of actually putting it in that trust that's protected. So I've seen clients that have actually put way more money into beneficiary designations or accounts designated for children. And it makes it even worse because that money gets spent down and squandered instead of providing for the entire family. So there's a lot of different mistakes and landmines that are out there that you have to navigate. And, that's something that we do on a daily basis to make sure that the money that you're setting aside for your loved ones do the best and most benefit possible. Also, if your assets are going through a probate, it's a very public. I talked about the advantages of having privacy. It's even more important whenever, this is sad to say, but there's literally people that scour and go through probate pleadings just to see who's receiving assets and see who can we now try to scam out of assets. We can't have that happen. We have to have a plan in place with loved ones being provided for and trusted resources overseeing those assets. You have to choose the right professionals and you have to choose the right people to step into those roles. We talked in general about, trust in general. I want to focus, and I think Taylor's going to spend a little time kind of talking about the different types of special needs trusts. Really three main ones, and there's, like anything, there's other subsets of all of these, but this is going to provide a good baseline as to what we're talking about and how best for you to provide for your loved ones.
So the first type of special needs trust that we'll discuss is a third party trust. So this is, if you're thinking it's third party because it's not created by the person with special needs or with the disability that we're trying to protect. Typically, this is established out of a loved one's estate plan, which we've discussed this evening already. Assets that don't already belong to that person with the special need, but most commonly when you have somebody with assets and a special needs beneficiary. It's created or funded upon the death of the trust maker or the grantor. It's typically a sub-trust of your revocable trust that you put into place that has now become irrevocable at your passing. Some important benefits here for the third-party special needs trust are probate avoidance, the ability to dictate what that beneficiary can use these assets for, and this trust, it doesn't have to be specifically irrevocable, but an important distinction here, as opposed to if we're just saying a general needs trust goes to beneficiary A, well, beneficiary B, who their assets are held in this special needs trust, cannot have any discretion over the assets or any ability to direct investments or revoke or modify this trust, because any control that they could exercise over these assets may be factored into that means test and may disqualify them from the public benefits we're trying to protect them from. So the main takeaway here is this is a trust that's created out of your estate plan for a loved one or a beneficiary who has a special need, and it comes into existence at your passing. The next type of trust from our graphic is a first party special needs trust. Here we go again with the synonyms. It could be a self-funded trust, a self-settled trust, a Medicaid payback trust. Lots of variations here, but the important thing is this type of trust is created if the person who has the disability inherits money or property or receives a settlement. Maybe there was a personal injury that led to the disability, or maybe there just wasn't proper planning put into place when a person with a special need inherits some money. So where do we go from there to kind of get them back onto those public benefits or protect them from being disqualified from those public benefits? Or if you develop a disability sometime down the line and need to start to qualify for those benefits, we can use this type of trust. And so that person with the special need or the disabled person can establish this trust. They must be under 65 generally at the time the trust was established. Any funds remaining in this trust at the end of their lifetime will be used to pay back the Medicaid that they've received. So that's a drawback compared to the trust that's created out of your estate plan, is when we establish this first party special needs trust. Generally, Medicaid needs to be paid back with the remaining assets. But again, overarching purpose of this first party trust is to help that beneficiary or that person qualify for supplemental public assistance. And then the assets in this first party trust can layer on top of that for any additional needs that they have. And the third type of special needs trust is generally what's called a pooled special needs trust. It's generally administered by a nonprofit for the benefit of multiple beneficiaries. So it's a separate account is maintained for several individual beneficiaries, but all of the assets are pooled together in terms of investment and management. A master trust agreement governs what all of those separate accounts are and what beneficiaries those special needs trusts are benefiting or being used for. And so generally this is, somewhere where we're moving these assets into this pooled special needs trust. Maybe it's a smaller estate or a smaller asset, but this nonprofit is investing multiples of these assets for the benefit of these beneficiaries who are named in this pooled special needs trust.
So I want to make a recommendation that that you form a team when we're talking about this type of planning. There's, for years, we've worked with a lot of professionals that have a passion for this. And I think that's something that's really important because there's a lot of knowledge that goes into this type of planning. You need an attorney, a law firm that knows what they're doing when it comes to this type of planning. Your financial planner should be a part of this, your insurance agent, your caregivers, and then likely future guardians if you have minor children or loved ones that are going to need guardians in the future. Have these people that specialize in their fields that know this type of information. Because like in any field, there's a lot of general practitioners. There's a lot of folks that haven't done it for a long period of time. Find those and search those people out that know what they're doing in these areas and put a team around you. You deserve it. And to find someone that says that they know how to do everything, usually they're not a specialist on the things that you need. So I think it's really important to look for those people that have a passion and work regularly and have the experience over years to do this type of work. I'll get off my soapbox. But with that, I also want to talk about, we talked about the carrying of the bucket. A lot of times folks, we have to go through the discussion as to who's carrying that bucket for their loved ones, who's managing the assets, who's making those hard decisions, who's paying out the money, following the rules. Your choices in that, just so you have knowledge whenever you're having this conversation with your attorney, you have the choice of picking those individuals, those family members, those friends. You also have the ability to pick corporate trustees. When you hear a First National Bank and Trust, they have trust departments, they have trust officers that all they do is oversee these types of trust and making sure that your loved ones aren't disqualified for that assistance. And so that's really important. And sometimes we even see a hybrid of that, where it's an individual that you trust along with that corporate trustee. Interview those people, talk to those people, see if they're comfortable with that role that they would be taking on. Sometimes it's also the same people that would be a guardian, but sometimes it's not. Sometimes you've got loved ones and family that would be great to be a guardian, but they're not the people that need to be overseeing, hundreds of thousands of dollars and overseeing and making good decisions on what assets should be coming out of these trusts and for what reasons. The important decisions that they're needing to make are protecting the assets, but then also on the next slide is what we're spending on. We're spending on the special needs, but not on support. Taylor's got some great information in regards to what they cannot use it for. And I think that's important to know, because he's going to go through what you can't use it for, but more importantly, what you can use it for, and what that supplement and what those great things that money can be used for.
Sure. So just kind of generally going back to those different types of special needs trust, one common theme runs through all of them. The beneficiary, the special needs beneficiary, cannot dictate what those monies are used for. They can't have control over the assets or direct anything, any decisions related to the trust. That's up to a third party, as John was talking about, that independent trustee or a corporate trustee in that scenario. So what can those monies be used for? Keep in mind, the goal here is to use the public benefits that this special needs trust beneficiary is already receiving, and those supplemental benefits or those public benefits are used to pay for food, rent, electricity, taxes, gas. So in Oklahoma and in many other states, Social Security or supplemental income and Medicaid benefits can be reduced if we're using these trust assets to pay for some of these things, because SSI is generally intended to pay for food and shelter. That's a huge category, and so it may seem tricky at some times, but just keep in mind that the point of that supplemental needs trust is to supplement what SSI and Medicaid benefits and other public assistance are not already paying for. What are examples of things outside that food and shelter category that SSI covers? Anything from home upkeep and utilities to personal hygiene, travel and entertainment, care management. I'm not going to read all of these, but as you can see, there are so many things that go beyond what the public assistance can pay for. And again, this is where, if you've worked hard to acquire assets yourself and now have a disability that needs to be cared for, or if you've worked hard to pass assets on to the next generation into that supplemental needs trust or special needs trust. These are all of the things that we can care for over and above that food and shelter that public assistance is already covering. So we've talked a lot about, the goal here is to keep assets that would disqualify us or disqualify that special needs trust beneficiary from receiving the public benefits that the government provides and that they're entitled to help provide for their care, with, again, a focus being on protecting them and providing for them after you're gone. So what are those public benefits? SSI and Medicaid, which we've spoken about at length already. Those are the main avenues that we see of concern, but there's also veterans benefits. Maybe you've served our country, and maybe as a result of your service, maybe you have a disability now that the government is providing benefits for. Well, we want to make sure that that's protected because it was so well deserved, and we want to protect those benefits that you're entitled to. Subsidized housing, temporary assistance for needy families, SNAP, some other programs. Sometimes you just need a hand up, and we want to make sure that hand up is protected from any inheritance that you may receive, things like that. Obviously, we're going to use all of these assets for your benefit, but we want to make sure that you are protecting these public benefits that are offered first, and also protecting that inheritance that you're receiving or the assets that you want protected in your self-funded special needs trust. So SSI is available to individuals with a disability who have paid into that, have a prior work history. There's no means testing for eligibility. So if I have a disability, in 4 years I've worked at Evans and Davis. I've paid into this. Now there's no means test for me to be able to receive that disability insurance. Um, and so that's another one of the public benefits that's available. Um, Again, SSI benefits can be reduced for countable income. There are just a lot of considerations there for any income that you have. It's likely to decrease some of the public assistance that you're receiving. And so we want to be able to protect that. Medicaid is another public benefit. It's means tested and it covers a broad range of medical services. So we've covered food and shelter with SSI. We've covered anything else from our loss of an ability to work with our disability. And so now Medicaid covers a broad range of medical services, but it's means tested, which we've discussed for other public benefits. So again, we come back to wanting to protect the assets that we have in our name or that we're inheriting so that we can continue to qualify for Medicaid. One state that I practice in a lot, from all the way from Tennessee to California, where we have offices and where Evans and Davis practices, is Oklahoma. So in Oklahoma, how do we determine eligibility for Medicaid? You have to be a resident of Oklahoma. You have to be in need of assistance or in a situation that would be characterized as low income, and a person must be in a category of people who can receive Medicaid. And the three most common categories would be children under 19 and their caretakers, pregnant women, and people who meet the SSI definition of aged, blind, or disabled. So generally, that's Oklahoma and several other states. That's how they would define your eligibility for Medicaid and for SSI. So those are kind of a general overview. And if you have more specific questions, again, this is going to be a very situation specific. So feel free to email us with questions about some of those public benefits that are available and ways to protect them. Another avenue that we go to when we look for financial success and for protecting people with a special need for their whole life is an ABLE account. And John's going to talk about ABLE accounts and how they can supplement the planning that you've done already.
Yeah, and I think supplement's a great word to use there, because I think ABLE accounts have been introduced relatively recently in 2014. And I think they're a good start. And I think it's something that the government has done to provide for and to not disqualify. But I think at the end of it, you'll see how there's some distinctions and some things that you have to be aware of, where there's some limitations that maybe a special needs trust doesn't have. And it's something that can complement. An ABLE account works basically it's an account that funds, cash is put into, and the funds grow tax-free for the benefit of that account holder. The ABLE account tax treatment is similar to that. Those of you all who are familiar with a 529, college savings plan. There's no federal income tax deduction on these ABLE accounts as well for the beneficiary when they're pulling assets out. There are some current bills to expand some of the reach of these. Right now, a disability has to have occurred prior to age 26. They're trying to push that to 46. So it's kind of baby steps. This is a very good start. I think it's going to get better over time. As of right now, the maximum that you could contribute in a year is $15,000. Hopefully that will increase as well. Another, the use of the funds, it's broad, but it's kind of like the self-managed trust, the things that we can use for, but there's restrictions there as well. And then also one of the things I think can be problematic is the account balance. If it exceeds $100,000, it's going to potentially and will disqualify again on the SSI, for example. So there's still issues there, but it's a good start. Obviously, it can get us past some of those $2,000 means testing. It's a good start and it's a complement. Right now, this is able accounts are available in multiple states. We have the ability to have this in 43 states and Washington, D.C. State rules, your specific state is going to dictate minimum contributions, some withdrawal restrictions, and some other things that the options for your investments. So work with a professional in your state that knows those limits and what can and can't be done. Every state's going to vary. For example, we work in Colorado. It allows non-resident enrollment, whereas where I'm licensed in Tennessee, it does not. So there's a difference there. Missouri, you can get one of these accounts started with as minimum amount of it as $1. Texas is 25. So there's different requirements. Some have a handful of investment options. Some have a bunch. It's really going to be different as you kind of go through it for what's specific to your locale and the professionals you're working with there. As you can see in those states listed in there, there's a lot of options and there's a lot of great resources out there for you to kind of compare for your specific scenario. As Taylor mentioned, we do a lot of work in Oklahoma. So I kind of want to walk through Oklahoma's, they call it their stable account, and some of the positives and some of the maybe some restrictions there as well. Positives, it's allowing people with a disability to save for the future. It's allowing them to have an account, typically up to $100,000 without a lot of downside, instead of having someone always. So for the folks that have that ability and can manage money to their extent that they're capable, it's a great tool for those folks. It doesn't count against that $2,000 cap on the qualification, and it's not subject to income tax, as we mentioned. Parents can direct life insurance proceeds. If they haven't done the next step and put that trust in place, they could direct life insurance proceeds to a stable account to allow for the proceeds from a life insurance policy, for example, to pay into that. There are some cons. There are some negatives to it, though. Obviously, we talked about the 100K max right now. A lot of lobbying is going on to try to expand that to provide more benefit. The biggest drawback that I think a lot of folks see is that upon the death of the account holder, those funds that are left would go to reimburse Medicaid services. So if if someone passes away with $90,000 in a stable account, for example, Medicaid has the right to come in and claim for all of the monies that they've paid in over time. So there's a downside to that, in the sense that that's not the case on all of the trust-based planning that we talked about previously. A trust, upon the death of the beneficiary, we have rules as to where those assets flow. Maybe upon the death of that child that had special needs, it goes into a cause that you're passionate about. Maybe it goes into other family members' trust. Maybe it goes to whatever your heart desires. But it's not restricted by that Medicaid payback, which these ABLE accounts are. So I think it's something, my professional opinion, it's something that's a great start, and it's a great thing for that independence. And it should be used in conjunction, not an either or, not mutually exclusive, but it's a really good thing that I think folks can use as a tool. But I think that's, this is a topic that we could spend an hour on and not just 3 slides. So like Taylor mentioned on some of the others, when you have questions on this, reach out to your professionals, reach out to us. If you have questions on that, we'd love to help kind of navigate this. We're not setting up stable accounts. We're doing the trust-based planning, but we want to be a resource, obviously, on the information and often the disinformation when it comes to that. Another topic that I see a lot of disinformation on that Taylor's going to speak on is the guardianship and navigating those waters for the folks that you care about.
Sure. So the role of guardian and the guardianship process is just another thing that plays into, if you are a caretaker of a child who has a special need, what's going to happen when they're 18, they've reached the age of majority, they have more autonomy now at law, but you still want to see those protections and your ability to care for them and make decisions on their behalf for them continue past that age. So if you wish, and if the scenario fits, you can pursue a guardianship, and you can be appointed by a court as the guardian of your child. You can initiate this as early as 17 and a half years old. And that guardianship can state that you can step in at age 18, that there's a need for you to step in and manage the medical and financial decisions that your special needs child will be making, as opposed to them having their autonomy on that. When they have turned 18, the court sees a need for you to continue to be able to make those decisions, and so you'll be appointed guardian. It will take some stress off of who's going to make those decisions, how's that role going to be managed, and like I said, you can do this as early as 17 and a half, and then this can take place at 18. So talk to your attorneys, or talk to us about the need here, because it is important to maintain a balance between an individual's privacy and independence and your desire to protect a loved one. So this might not come into play in every situation or scenario, but in your scenario, when your child with that special need has reached 18, you may want to continue to access, health records, take an active role in IEP meetings, any other legal action or healthcare actions. Applying for a guardianship might be the right fit for you to continue to make those decisions and continue to care for that child.
So how can we help? There's a list there, and those are really just some of the tools. As Taylor alluded to, every family is different and every situation is different. There's not a canned answer, and there's not a one size fits all, and especially with this type of planning. I want to switch on to the next slide and give you our contact information. We are bumping up against an hour, and I'm so thankful for everyone that's joined us. I hope you got a lot of benefit from the information that we provided. I want you to reach out to us and ask any questions that you have that may have come up during this presentation. Our goal is to provide you with a comprehensive plan and making sure that your family and the people you care about are, taken care of. The finances that you worked hard for go to the people that you love and care about. And that's really why we love what we do. And that's really why, people give us hugs and cookies when we've protected their family. And it's a great, it's a great thing that we get to do. And I really appreciate you guys joining us for this. We are recording this presentation. So if there are people in your life or there are people that you know that would benefit from this information, we'll send this out to everyone. Please feel free to share it and provide it to the people that you think could benefit from it. And that's really it. Thank you all again for joining us tonight. On behalf of Taylor and Shelby and our team, thank you, and we appreciate you.
Thanks, everybody.